My brief is misplacement.
Brief is misplaced. Who has taken away your brief? It's a serious matter.
Well, I know, my lord.
What do you want?
My lord, kindly accommodate me for 2 weeks, my lord. I will reconstruct the brief.
All right, Mr. A.K. Professor and a counsel appearing for the writ petitioners in this case submits that the brief has been misplaced in his office and therefore hearing of this matter be adjourned for 2 weeks.
My lord, I am obliged.
Although this is an old matter, yet considering the ground on which the request is made, the same stands allowed,
I'm
let the
obliged.
matter be listed accordingly.
I'm obliged.
Yes,
May I please, Your Lordship? I beg to mention item number 9.
yes.
Lordship, I am appearing on behalf of respondent number 3. We have filed an affidavit in opposition. I'd humbly pray the same may be called for. Deeply obliged.
My lord, this matter may be listed for motion tomorrow, my lord. The matter is very urgent.
What is the urgency?
Urgent, my lord, because it's the cancellation of registration of a doctor, my lord. And he has been given only 3 days time to surrender his original certificates, my lord. So,
Do it on Monday. Because
My lord,
tomorrow list is already out.
my lord, supplementary list is not.
This bench is not available. Therefore, huh? Therefore, I don't want to. You can wait till Monday. What is the earth-shattering urgency? Monday.
May I please, Your Lordship? Lordship, I beg to mention for listing of a admission matter, Lordship, in the next week, Lordship, because
Third week of November.
Lordship, because it matter pertaining to dismissal from service, Lordship, and he is fast approaching the age of superannuation in the month of February, Lordship, and in this matter, Lordship, 3 months ago, Lordship, notice was issued and no affidavit has been filed, Lordship.
Third week of November. Yes.
Lordship, I beg to mention for listing, my lord, on 25/11, my lord.
Third week of November.
Most of them.
My lord, similar player, my lord.
All third week. Before third week,
Obliged.
no listing will be allowed.
Obliged.
May I please, Your Lordship? Lordship, I beg to mention item number 10. Lordship, yesterday we had submitted an adjournment slip. Lordship, we have established contact with the client. They will be signing the rejoinder affidavit within 2 weeks, Lordship. Some time may be allowed, Lordship.
These are 2014 matters.
Yes, Lordship, last opportunity, Your Lordship, on the last occasion also it's granted us time. Lordship, we have contacted them. They will be coming down to sign only, Lordship.
This writ petition, which was instituted in the year 2014, and therefore is a 10-year-old matter, is listed today for hearing. However, Mr. H3
A. Chakraborty.
A. Chakraborty, learned counsel for the petitioner, seeks adjournment on the ground that some time is required to bring on record the rejoinder affidavit. Full stop. It is not understood as to why the petitioners could not file rejoinder over the last several years. Be that as it may, on the request of the petitioner's counsel, hearing of this matter stands adjourned for 2 weeks. It is made clear that no further adjournment will be granted in this case on the next date.
Obliged, Lordship.
May I please, Your Lordship, I beg to mention for listing of a writ petition in the admission column.
Third week of November.
Much obliged.
May I please, Your Lordship? Lordship, I beg to mention for listing of a review petition for orders, Lordship.
Third week of November.
Lordship. Obliged, Lordship. Your Lordship, I beg to mention WPC 136 of 2022 for a master roll worker in pension matter. Your Lordship, some similar matters have been listed in this month. So Lordship, due to urgency, may this matter be listed.
Which is a similar matter? What is the case number?
Your Lordship, 136 of 2022.
It is listed when?
No, it has not been listed yet. But some other similar matters have been listed.
Third week of November. When the matter is listed, then you get an order tagging.
Your-
What is this?
May I please,
This
Lordship?
writ petition was disposed of earlier.
Yes, my lord, review petition was again filed, my lord.
Ah.
My lord will peruse order date 26/9/24. That is there in the file, my lord. Review petitions order, my lord. So
Mhm.
their review petition was, my lord, allowed, my lord. And
All right. So what is to be done today?
my lord, we'll have to file affidavit now, my lord.
Lordship,
There are 5, my lord, of the order, my lord.
All right. Yes.
My senior is out of station.
All right.
Matter may be fixed on 11.
No. Who is your senior?
RP Hazarika.
And what is your name?
Yeah, Hussain.
Mr. A. Hussain, learned counsel, is appeared for the petitioner. This writ petition was earlier disposed of by the order dated 8/3/2021. However, subsequently, by order dated 26/9/2024, passed in review petition number 1 of 2023. The earlier order dated 8/3/2021 was reviewed. And the writ petition was restored to its original file for fresh hearing. Full stop. Today, the matter has been posted in the motion column. I have perused the statements made in the writ petition. Mr. R. Dhar Lanet, additional senior government advocate Assam, appearing for the state case for 4 weeks time to obtain interaction in the matter. Issue notice returnable in 4 weeks. Since Mr. Dhar has appeared and accepted notice for, yeah, for SCPWD.
My lord, I will appear for all, my lord.
SCPWD, SCPWD, huh? For all the respondents, no formal notice, extra copy.
Copy. They will serve copy, my lord.
Yes, extra copy.
May it please your lordship, on the last occasion, the learned government council was supposed to bring instructions in regard to the
Yes,
appeal.
what has happened to his appeal?
Appeal is numbered, lordship. It is under process, lordship.
So you file an affidavit.
Lordship.
The appeal has been registered and it is in the process of being disposed of. So your name, please, Miss N.K. Brown,
N.K.
counsel has appeared for the writ petitioner. In terms of the order dated 30/10/2024, Mr. S. Datta, learned standing counsel, Revenue and Disaster Management Department, Assam, has obtained instruction and submits that the appeal referred by Yasuddin assailing the selection of the petitioner for appointment in the post of Gaon Pradhan has been registered and the matter is under process for final disposal. First of Mr. Datta, however, seeks 4 weeks time to file an affidavit bringing on record the status of the appeal. Prayer allowed, issue notice returnable in 4 weeks. Since Mr. S. Datta, learned SC Revenue Department, Assam, has appeared and accepted notice for
1 and 2.
1 and 2, and Mr. A. Chakravarti, learned Government Advocate, Assam, for respond numbers 3, 4, and 5, service of notice upon the said respondents is deemed to be complete in this case. Extra copies of the writ petition, requisite in numbers, be furnished to the learned departmental council so as to enable them to obtain instruction and file affidavit. Petitioner to take steps for service of notice upon respond number 6, where registered post with AD. This is the matter again after 4 weeks. Same order in the other case, list along with item 2. Item 3 also same order,
Same.
list. Yasuddin is the appellant in the other
Yes,
matter also.
Yes. Habla.
Item 4.
May it please your lord.
Yes.
So this matter relates to removal of the petitioner from services in a disciplinary proceeding, my lord. But even in this case, my lord, the inquiry that has been held against the petitioner, my lord. After discarding that inquiry on the same set of charges, another inquiry was held without citing any reason, my lord, which dehones the rules as stated in the Assam Services Discipline and Appeal Rules, my lord. That is my case.
Argu?
My lord is taking this matter today, my lord, for fixing for hearing, my lord.
Take it up.
My lord, my lord issue rule and then fix for hearing in the next week or after 2 weeks. We will get the record also in the meantime.
Record was already earlier, it was there, my lord.
All right, we'll fix it then. You produce the record on that.
My
day.
lord.
We'll fix it. Mr. You're Mr.
Lordship S. Borua.
S. Burwal, and counsel for the writ petitioner. Peruse the amendments made in the writ petition. The petitioner has approached this court challenging the order dated 3/4/2021,
And
by
it's
means
at
of
12.
which he was removed from service. Full stop. After hearing the arguments of learned counsel for, next, Mr. R. Dhar, learned, additional senior government advocate Assam, has appeared for all the respondents. After hearing the submissions made by learned counsel for both the sides, this court is of the opinion that the matter would require detailed hearing based on the departmental record. As such, issue rule returnable on 12th of December 2024. Since the parties are already represented, no formal notice is required to be sent in this case. Register list this case as a fixed item on 12/12/2024 for hearing. The learned departmental counsel to bring the records on the next date.
Deeply obliged.
Item 5.
May I please, Your Honor? My lord, I am appearing on behalf of Mr. P.K. Roy Chaudhary, my lord. My lord, he is on Lake Port number 2, my lord. Kindly pass over for the timing.
What is this matter about?
Lordship, for pensionary benefit for the second wife is next of kin certificate is for applied for by the first wife first, which is not finalized yet. Lordship, the second wife has filed this writ petition, Lordship, seeking pensionary benefit.
You filed affidavit.
We have filed affidavit, Lordship.
Written copy. Time being.
Most of them.
Item 6.
My lord, A.K. Mount senior advocate, he appears in this case, so he's coming, my lord. Can you pass over for the timing?
Oh, that, yes,
Otherwise, as per lawsuit's direction, we have written to the authority to the LGBI lawsuit. Probably they have passed some matters. Last paragraph, my lord, may kindly please last paragraph. The order which was impinging here lawsuit, we have said that it is not a valid order. And 4 lawsuit, serial number 4 lawsuit.
so what has happened by 5th of
After that lawsuit, they have. Keeps going.
So his retirement has been maintained.
Lordship, that part I have no knowledge. Otherwise, regarding this particular which was impinging lordship, that is not a valid order as because the person was retired. That part we have directed as per lordship's direction. We have directed to the authority of the LGBI to lordship take a corrective measure lordship. And regarding some our officiating director has passed the order. Whether he can pass that part lordship, I cannot submit lordship. That part lordship has to decide lordship.
Have you seen this order?
No, I think.
Please give him a copy. All right, let Mr. Mohanta come.
Yes, ma'am.
But then now this matter has become infructuous. You have to challenge the other order now. You consult
Yes,
Mr. Mohanta. We'll take it up after a little while.
Lordship.
Our orders items 7 and 8.
Lordship, though as a Union of India has filed an stay vacation petition, Lordship, matter will needs to be heard because cancellation of caste certificate is involved on the basis of which drawn proceed. Lordship, fix on a hearing date, Lordship, for admission, Lordship.
The applicant is Union of India.
Lordship.
And you are for?
I'm for response.
They have cancelled the caste certificate of the red petition. two writ petitions are involved also. One departmental proceeding, other is the lordship. Applicant.
Sit down, Mr. B. Chakraborty, learned CGC is present on behalf of the applicant in IA Civil 3310/2023, arising out of WPC numbers 7691/2022, wherein a prayer has been made to vacate the interim order operating in this case. However, the learned counsel for the opposite party stroke writ petitioner is absent when the matter is called up. Mr. Goswami, B.D. Goswami, learned additional AG, State of Arunachal Pradesh, is present on behalf of the other official respondent. Be that as it may, since the counsel for the writ petitioner in both these writ petitioner in WPC number 7691 of 2022 and the connected petition in WPC number 688 of 2022 are absent today. This matter stands adjourned for 10 days.
Should I fix on any hearing date for admission, lordship?
On the request of Mr. Chakraborty, this matter is directed to be listed again on 12th of November 2024 as a fixed item. Interim order passed earlier to continue till then.
Item 9.
Yes, my lords. I beg to appear for respondent numbers 2 to 8.
May it please your lordship, as per office note dated 28/8/2024, my lord, the steps upon 8 to 24 has been completed. 8 to 24.
Lords, I appear for respondent number 8 as well. My learned friend is saying 8 to 24. I'm here for 8. From 2 to 8, I'm here. For respondent number 3, we filed our affidavit in response, which my lords, my learned friend had just mentioned in the morning, requesting my lords to have it on record. And that's in the main writ petition. There's an IA that my learned friend had filed, to which they filed a rejoinder 2 days back. I've been served with it yesterday. And my lords, I have also separately filed an IA under Order 1, Rule 10 on behalf of respondent number 3, respondent number 2, my lords, before the Diwali vacations. My lords, I have the filing number, which is 12950 of 2024. My only request is, my lords, whatever date the writ petition is listed, that IA can also be placed along with the writ petition, my lords.
All right. Heard Mr. S.P. Sharma, learned counsel appearing for the writ petitioner. Also heard Ms. K. Fukun, learned CGC, appearing for the respondent number 1. Full stop. Mr.
Zoravar Singh.
Zoravar Singh, learned counsel, has appeared for respondent numbers 2 to 8. Luajima Court order dated 28/8/2024 goes to show that service of notice has been deemed to be complete on the other respondents in this case. As such, the writ petition is ready as regards service. At this stage, Mr. Singh, Mr. Z. Singh, Zoravar Z.
Yes, ma'am.
Very catchy name. Z. Singh, learned counsel for the respondent numbers 2 to 8 submits that a separate IA under filing number 12950/2024 has been filed in this case on behalf of respondent number
2, my lords.
2,
Please.
seeking
My lords, deletion from the array of
deletion
parties.
of his name from the array of parties, but the same has not been listed today. Taking note of the submissions made at the bar, registered to list this matter for in the appropriate column. Again, after
My lords, can I request for a fixed date, my lords?
10th of December, ma'am.
on 10th of December, along with the connected IA.
My lords, can it be 11th? Can I please request for 11th, my lords? 10th, I have an arbiter. Or 12th, my lords, if that's convenient.
Oh, 11th, fine.
11th.
My lord,
Highly obliged.
I have an interim order, my lord.
Interim order passed earlier to continue till then.
Absolutely.
My lords, with regards, my lords, can I just make a small submission? That interim order is actually not a continuing order. My lords can have that order that says, in case a vacancy exists as on that date, we will keep it open. I have no difficulty in that. So it's not a continuing interim order. That's all. Highly obliged.
My lord, kindly pass over the matter for time being, my lord.
Just for what? Yes.
I have no objection, my lord. I'm ready to.
Then we'll go to some other date. Why you want Passover?
Oh, my lord, my senior is stuck in traffic, my lord. He's just coming.
Traffic? What traffic? 11 o'clock. What is this matter about?
My lord, from the petitioner was a secretary of Dakshin Defli Bohmukhi Samabhai Samiti Limited, my lord. He was show cause, my lord. Thereafter, he has filed a show cause reply also, but he has been removed from his from the post of secretary, my lord. Very arbitrarily, my lord.
Very
Arbitrarily.
What is the arbitrariness?
My lord, if we go through to the show cause notice, my lord, at page 24, my lord.
At page 34.
Page 24, my lord. The translated copy, my lord. The original was given in Assamese, my lord. Nowhere in the impugn show cause notice, my lord, it is mentioned that he may be removed or he may be discharged from the service, my lord. Just a show cause notice was sent to just asking some answer, my lord. And accordingly, the petitioner filed a show cause reply, my lord, wherein thereafter, my lord, without going through to the proper my lord, the violating the principle of natural justice, my lord, he was not given any opportunity to defend his case also, my lord.
You argue your case.
Yes, my lord.
The petitioner was serving as what? Secretary?
Secretary, my lord.
Secretary of?
Secretary. Dakshin Defili Bohumukhi Samabhai Samiti Limited, Gandhibari, my lord.
Is he a government servant?
No, my lord. He was appointed by the but it is under the Cooperative Societies Act, my lord.
That's all right, but he is not a servant. He is not in service of the state government. Some disciplinary appeal rules will not be applicable.
But my lord, he was a secretary, my lord.
I am asking you something, you are replying something else.
Yes,
I am asking, is he covered by the Assam Service Disciplinary Appeal rules or not?
No, my lord.
No. All right. So what is the violation in this show cause notice?
Yes, my lord. I'm going to. My lord, the principle of natural justice and administrative fair play, my lord. At first, the petitioner was show cause. When the petitioner was show cause, at first, he should know at least that why he was show cause, my lord. And the consequence of the show cause, what would be that should have been mentioned in the show cause notice, my lord. And the allegations so brought on that show cause notice, my lord, that is also not proper, my lord. If we go to the my lord, kindly have a look at page 24, my lord. I am going to. Show cause notice. With this notice, you are hereby asked to answer the following questions by 21/5/15 and submit the same in the office of the Cooperative Society before 2 p.m. My lord, 5 questions were there, my lord. For the first question, for December 2015 to the month of January, one person was not given to the fare of vehicle and labor charge for home delivery of AAY rice. Why? Give reason. The second question was why a direction was given to the agents for distribution of 50 kilogram of AAY rice instead of 66 kilogram. Give reason. During your tenure of secretaryship for the month of November 15, the stock of APH rice in the godown is shown to be less as compared to the record of the register. Give reason why. During your tenure, the secretaryship for the financial year 2015-16, 93200 liters of kerosene oil was shown to have been received, which is less than the result. There was a loss of the customer of the cooperative society and that of the agents. Why kerosene could not be received, give reason. On receipt of notice that is so and so from the in charge of Gandhibari police outpost, I was informed that you have been arrested in under section 366 and 506 IPC, and further I was informed to take necessary action against you. For that reason you have been suspended till date. Now let us know whether you have been acquitted from the aforesaid case or not. If you have been acquitted from the said case, then submit with a proof and proof to the Samavai office from the court and the police to that effect. But against this show cause notice, my lord, the petitioner filed a reply, my lord. The reason, the first question, my lord, answer is the reason for non-payment of home delivery, vehicle rent and labor charge for the last month of December 15 January was the agents have not deposited the bill and some agents have been paid. So far the agents did not file raise their bill. That is why that was not given, my lord. And some agents were been agents has been paid, my lord. The second answer, my lord, I have not issued any written order for providing 55 kg rice under AAY in spite of 66 kg. He has not passed any written order.
All right, so now what is wrong with it?
Thereafter, my lord.
What is wrong with the order at page 29?
My lord, I'm coming to that, my lord. Thereafter, my lord, Annexure 7, my lord. At page 29, my lord.
Yes.
As per proposal number 3 of the executive meeting held by the board of directors of Dakshin Defili Bhumukhi Samavai Samiti held on 25/5/2016, you are hereby discharged from the secretary post of this Samavai. He has been discharged from the post, but why he was discharged from the post, my lord, it has not been explained, my lord. Here. Neither it also, my lord, as per the proposal number 3. What is the proposal number 3, my lord? Till that I am not aware about that, my lord. Instead of asking them, my lord. My lord, on the last occasion, my lord, this honorable court, my lord, directed the respondent authority to file the proposal number 3 of the executive meeting, my lord. But till that they have not filed, my lord, before this honorable court also, my lord. The order dated, my lord, 29/11/2021. On that date, my lord, this honorable court directed the respondent, my lord, side, my lord, to produce the proposal number 3. Because I have been discharged from my service, my lord, as per proposal number 3 of their meeting, my lord. But what was the proposal number 3, my lord? Till that I have not been aware.
What is the proposal number 3? So now the board has changed now. This is 2016.
Yes, my lord, that is true, my lord. But my lord, in addition to this, my lord, actually during his tenure, my lord, he has
So he was dismissed almost more than 8 years back.
My lord, page number, my lord, 12, my lord.
This appointment of secretary is for how many years?
He was appointed.
Where is his appointment order?
Appointed on 1/1/2015, my lord.
Where is the order of appointment?
Appointment. That was 16, my lord.
So this is all temporary appointment.
Yes, my lord.
Then it's not a permanent appointment. Eight years have gone already.
This is the appointment letter, my lord. This is only available with me, my lord.
No, you please answer the question. He was temporarily appointed by a board resolution.
Yes, my lord.
By a board resolution, he has been removed.
Yes.
Resolution number 3 is a resolution of removal
Yes.
or discharge.
Yes, my lord.
So there was some allegation, they asked you, your client, you replied, they were not satisfied, they removed you. What is wrong about it?
But my lord, as per so far the my lord, the discharge order is concerned, my lord. So as per proposal number 3, what is the proposal number 3?
Proposal
Till date,
number 3 is to remove you, discharge you.
but till date, my lord, it is not been informed to me, my lord.
You file RTI application. You can't get back to service after 8 years.
May I please, my lord?
Yes.
My lord, regarding the same issue, a matter is pending before the Honorable Division Bench, my lord. May I
What division? Will you- What is the proposal number 3?
My lord, as per the proposal number 3, the petitioner was suspended from the post of secretary of the Doksin Defili Bohumukhi Samabay Samiti Limited.
Let us pass on. So this is a completely private.
My lord, in addition to this, my lord, when the petitioner was serving as a secretary, my lord, at that point of time, he has taken, my lord, several loan, my lord, unsecured loan in favor of the Samabay Samiti, my lord. So I have stated in my paragraph, in paragraph 17, my lord, page 12, my lord, wherein the petitioner is yet to receive 7,36,501 from the Samabay, my lord.
But this is a writ petition. These are all private engagement, cooperative society, secretary. This is not government office. The register only has the duty to oversee the functioning. You are not in government employment. So what can be done?
Then also, my lord, if I close the register, before the register also, my lord, the time is also.
Time is this. You approach the register with your grievance.
Limitation.
Limitation, what can be done? You can't be reinstated. That's not possible.
Yes, my lord, but that money can be, my lord, that amount 7,36,501 that has been that was taken unsecured loan, my lord, in favor of the Samabay, my lord, and filed, my lord, later dated, my lord, at page 37, my lord, I'm going. The responding authority given this letter, my lord, wherein they have stated that if any amount of money is to be given to you from the Samabay, then shall be given after the completion of the government audit. After completion of the government audit was also done, my lord, then thereafter also.
You can't get money in a writ petition. You have to file a suit.
Yes, my lord, but.
All right, enough. Yeah, mister?
My lord, can it be done, my lord, if I approach the before the register, my lord, the liberty may be given, my lord, so that I get relief, my lord, son.
Then you have to withdraw. Otherwise, how do you get liberty? If you want to withdraw an approach with the register with your grievance, then it is another thing.
Because there is question of limitation also, my lord.
What limitation? This writ petition is not maintainable. This is a misconceived petition. Now, after the dismissal, you will look up the law and understand what is the mistake. This writ petition should not have been entertained in the first place. Then your client would have been happier. Samabay Samiti Limited Service, what the writ court can do about it? Supposing there is violation of principle, then also what can be done? These are private organizations. Then,
yes, madam.
Then that's how it is. Your name, please?
A. Rashid, madam.
Heard Mr. A. Rashid, like a counsel appearing for the writ petition act. Also heard
Sincere
Mr.
apologies, Your Lordship. Right.
Yes, anything you have to say?
Yes, Lordship, he is not a government servant, Your Lordship. He is appointed by the society. He was removed by the society, Your Lordship. He could have approached your register of cooperative society, Your Lordship, but that's not the case. Your Lordship.
That's what he should have done. I was telling him,
Yes, your lordship.
they wake up after 8 years, 9 years. Also had Mrs. So-and-so and नाम तो किया सके B. Rajkumar and Standing Council Corporation Department Assam, appearing for the respond numbers 1 to 4, is it?
Yes.
Therefore, 1 to 4. None is appeared for the remaining respondents. Full stop. By filing this writ petition, the order dated 8/6/2016, by means of which the writ petitioner, who was serving as secretary in the Dakshin Dafeli Bohumukhi Samavai Committee Limited, page 29, you will get it, was discharged, has been put under challenge. Full stop. The facts of the case lie in a narrow campus. Full stop. The petitioner was temporarily appointed as secretary of the so-and-so committee by order dated 1/1/2015, based on resolution number 1 of the managing committee. While functioning as the secretary, certain anomalies were detected, which had prompted the cooperative society to issue a show cause notice upon the petitioner dated 18/5/2016, asking him to explain his conduct with regard to the issues raised therein. First step. The petitioner submitted his reply on 21/5/2016. Thereafter, as per proposal number, not being satisfied with the reply, as per proposal number 3 of the executive meeting held, as per proposal number 3 of the meeting of the board of directors, executive meeting, close, the petitioner was discharged from the post of secretary. Full stop. This writ petition has been filed inter alia, contending that the respondents have acted in violation of principles of natural justice by failing to give proper opportunity to the petitioner to explain his stand. Full stop. The learned departmental council has, however, questioned the maintainability of the writ petition by contending that this is a purely private appointment made by a non-governmental organization, and therefore a writ petition, therefore the writ petition would not be maintainable. According to Mr. Rajkumar, if the petitioner had any grievance against the functioning of the board of directors of the society, he ought to have approached the Register of Cooperative Societies by filing appropriate application. Full stop. It is the admitted position of fact that petitioner is not a government servant, nor is the provision of Assam Service Disciplinary and Appeal Rule 1964 applicable in this case. Full stop. Therefore, there is no question of violation of any statutory provision in this case. Full stop. Insofar as the principles of natural justice is concerned, as has been noted above, the petitioner was given an opportunity to show cause and submit his reply. First up, once the reply is submitted, it would always be open for the employer to consider the same and take a decision in the matter. Full stop. Moreover, the petitioner was in temporary appointment based on a resolution of the board of directors, and therefore there is no reason for this court to hold that he could not have been discharged by another resolution of the board of directors if there was cause and reason in the opinion of the board to do so. Full stop. For the aforesaid reason, I do not find any good ground to entertain this writ petition. The same is accordingly dismissed. It would, however, be open for the petitioner to ventilate his grievance before the statutory authority in accordance with law, if so advised.
Deeply grateful, your lordship. My apologies.
Pending number, identified.
Well, the case of the petitioner is this. The petitioner is the daughter of the person working in the state veterinary department from the second wife. After the death of the father, she is entitled to for the share of the family pension, which was not provided to her. That is why she is before the honorable court. She is an unmarried daughter. After the amendment of the pensionary rules that I have annexed at page 44.
Yes.
My lord, this is under proviso of Article 309 that 69 pension rules was amended. My lord, in the amendment of Rule 143, in sub 2A, in sub rule 1, Roman 1, in clause D, the word unmarried minor daughter shall be substituted by the daughter, unmarried dependent daughter. Then, my lord, the provider, provided the family pension shall be allowed to continue beyond 21 years of age to an unmarried dependent daughter of a government servant, pensioner, subject to the fulfillment of the following conditions: that there is no disabled child eligible for the lifetime of the family pension, that a certificate of non-marriage and non-employment in the prescribed format duly certified by the CEO, BDO concerned shall be furnished by the unmarried dependent daughter to the treasury or bank once in a year. And for this reason, my lord, I am entitled to, at page 48, I have given the certificate from the my lord BDO, page 48. In page 48, this is a certificate. I declare that I have not been serving in the capacity either in the government department, corporation, such and such, signature, late, and certificate of non-marriage, verified and found to be correct, given by the block development officer. Government has filed an affidavit stating that I am entitled to get the pension. And the respondent number 8, the first wife, filed an application for the kin certificate, which was only giving the name of the first wife and a son, which was subsequently, on my objection, it was cancelled, and an order was passed to give them a fresh application for the kin certificate with all the legal aids.
What is the stand of the government?
Government stand is that the affidavit filed by respondent number 1, 2, 3, 5, and 6. My lord, the paragraph 11, that as regards the statement, page 57, statement made in para 11, the petitioner, the deponent begs to state the deponent agrees that as per amended Assam Service Pension Rules, an unmarried daughter is entitled to family pension benefit. And previously, my lord, my mother, the second wife, there was a dispute with the father, filed an application for maintenance. I was getting the maintenance. The wife was not entitled to get, my mother, but I was entitled to get. So I was getting some amount. Now I am studying in, my lord, this bachelor, 4-year bachelor technology, Department of Agriculture Engineering in Assam University, because without the money, I cannot pursue my studies. That is why I am before you.
And who is the authority to take a decision in this
My lord,
matter?
the authority to take a decision is, my lord, Accountant General, my lord.
Accountant General.
Not the Accountant General, sorry, he is giving it. Well, it is the 2 and 3, I think, in my case. 2 and 3, no? 2, my lord. Commissioner Secretary, Government of Assam, Pension and Public Grievance Department.
Yes, what do you have to say?
Oh, my lord, we have already filed our affidavit, and we have already stopped the process of pension papers, processing the pension papers, so that the unmarried daughter can get the pension.
I'm appearing on behalf of respondent number 8, that is the first one. I have 2 submissions to make. May I please your lordship? Lordship, my submissions are in 2 folds. First, that the pension amount, in accordance with the Assam Services Pension Rule, the pension amount has to be disbursed in accordance with the amendment, which has been annexed by the petitioner themselves. Under note 2 that the eldest surviving person should be given the pension. So herein the eldest surviving
That is in
person,
case all are minors.
all,
You read the first part of note 2. Equal shares.
yes, equal shares,
Then
equal shares.
Why are you reading the part which is not relevant here? Only
No.
because it helps you.
Lordship, under the circumstances herein, my son, he is not eligible for pension as because he has crossed 18 years of age. Herein the two persons are there, as in for the petitioner and me, as in for the eldest person. So given the scenario, there are certain other factors. The eligibility, as in for being an unmarried person and unemployed. So undoubtedly they have annexed a document, but we are disputing that particular aspect as given the scenario.
That the authority
that is there.
Examine.
That is there. And in my aspect, I'm a aged lady. For my maintenance and other things, I have no other source of income. That has
So
to,
that these arguments are meaningless. She also doesn't have it, but we are not on that. We are on what the rule says.
yes,
As per rule, she is entitled.
yes, and
What can be done about it? You have to take your seat.
Lordship,
No, you can't argue against the rules, can you?
yes, a humble prayer. At least the pension amount should be in that way that once she is married or she receives any kind of employment, it should not be disbursed any further.
That is as per rule. There is no need for to say anything.
Lordship.
Whatever the rule is, as per rule, they have to do it. We'll only say that.
Lordship, and the pension amount may be disbursed in my account, and in accordance with that, if it may be further, as because there are other provisions of indemnity bond that can be complied with. And
It will be done as per note 2.
Lordship,
It will be divided in equal shares. Why should it be given to your account?
Lordship, equal shares
You
in
want to control?
no Lordship.
Then petitioner then.
No Lordship. Lordship, in this particular note, it has been mentioned that the
So what is your name?
TR Sen, Lordship.
Huh?
TR Sen.
TR Sen. So Mr. Sen, when you argue a matter before the court,
Yes.
the first principle is you must yourself be convinced that the argument you are making has a legal backing.
Yes.
Not only because your client wants it. And once you are convinced, then you have to tell the court what is the legal principle based on which you are arguing.
Yeah.
Otherwise, don't argue in the High Court. Do not open your mouth in the High Court. Arguing in a district court is on facts. Arguing in the High Court is always on legal principles. What you are saying is contrary to the legal principles. What you are saying is also divorce of any legal principle. So how does the High Court accept your argument? Because the orders we passed will lay down a binding precedent.
Yes.
Therefore, we have to go by the principles of law.
Yes.
And you are making submissions which are divorce the principles of law. So net result is you are wasting the time of the court. Is there any other interpretation possible?
No.
If possible, you tell me.
No Lordship. These are the submissions which I had to.
Then you have made it. You have made your submission. But do you realize that these are completely without the backing of law? You are saying things which do not have any backing of law. You have to tell the judge, this is the law. This is why I'm asking for this. Then the judge will decide. But if you're saying something which has got nothing to do with law, these arguments, why should the court hear your arguments? It is wastage of judicial time. Do you agree?
Lordship, in this aspect, these are the submissions which I had to make.
So you know this much, so whether it is okay or not, you are not bothered, is that?
Nothing like that. Sincerest apology, Lordship, on that.
All right.
Deep
All right. I've taken note. Take note. Anybody else?
I appear on behalf of respondent 2 and 4, Lordship, and the 4 filed one affidavit in opposition that has stated that the earlier next of kin certificate was issued on 7/6/23. It was cancelled, Lordship, and subsequently one letter was been communicated to the private respondent number 8, Lordship, to ask to submit a fresh application for the purpose of next of kin certificate, Lordship.
So that will make it clear that they will produce all relevant documents and certificates.
To submit the same.
But subject to submitting all relevant documents and certificate, their claims will be processed in the light of amended provision of the rules. Yes. Heard Mr. P.K. Roy Chaudhary, learned counsel appearing for the lead petitioner. Also heard Mr. Your form appearing for? Who's one?
One is
MM Kotoki, learned standing counsel, Animal Husbandry and Veterinary Department, Government of Assam. appearing for respondent numbers 1, 3, 1, 3, 5, and 6. Mr. A. Chakravarti, Learned Government Advocate Assam, appearing for the respondent numbers
4 and 7.
2, 4, and 7,
Seven.
and Mr. T.R. Sen, Learned Counsel, appearing for the respondent number 8. Full stop. The writ petitioner herein is the daughter of a deceased government servant born through his second marriage. Full stop. Earlier, the deceased government servant got married with the respondent number 8, out of which, and out of their wedlock, a son was born who has now attained the age of majority. Full stop. However, the writ petitioner is an unmarried daughter of the deceased government employee, namely late Ujjal Deori, and therefore she claims to be entitled to a part of the family pension payable on account of her deceased father. The dispute in this case arose on account of the competing claims between the respondent numbers, between the writ petitioner and the respondent number 8 as to the share in the pension. Full stop. As to their entitlement to receive share in the pension. Full stop. According to the petitioner, after the amendment of Rule 143 of the Assam Service Pension Rules, it is 1969 rules, an unmarried dependent daughter would be entitled to receive pension subject to fulfillment of the conditions mentioned therein. Full stop. Mr. Roy Chaudhary submits that since his client is the unmarried dependent daughter of late Ujjal Deori, and she is presently pursuing her studies in the Assam, which college?
My lord, she studies in Assam Department of Agriculture Engineering at Assam University, Silchar.
Department of Agriculture University in the Assam.
Agriculture Engineering at Assam University, Silchar.
Agricultural Engineering and Assam University, Silchar. Can you give the name in writing?
My lord.
Hence, as per the amended provisions of Rule 143 of the pension rules, she is entitled to receive pension. Full stop. Mr. Roy Chaudhary further submits that since the son of the respondent number 8 has already attained majority, hence the pension amount is now required to be split in equal proportions between the writ petitioner and the respondent number 8. Full stop. A writ of mandamus has therefore been prayed by the petitioner to the above effect. Full stop. The respondent numbers 1, 3, 5, and 6 have filed counter affidavit whereby they have admitted that as per the amended provision of the Assam pension rules, the petitioner being the unmarried daughter is entitled to a share in the family pension. Full stop. The respondent number 4, represented by Mr. Chakrabarti, has also filed an affidavit taking more or less a similar stand. But according to the respondent number 4, the respondent number 8 has failed to submit
Raise the proposal for next of kin certificate, Lordship. Relevant documents, asked to submit the relevant documents.
has
Lord.
failed to submit the relevant documents, including the next of kin
Next of kin
certificate
certificate.
for processing the pension
Right.
claim. Full stop. Mr. Sen, learned counsel for the respondent number 8, has argued that his client is old and solely dependent on the share in the family pension. Full stop. He has, however, admitted in his fairness that as per the amended provision of Rule 143, an unmarried daughter may be entitled to, unmarried dependent daughter may be entitled to a share in the family pension. Full stop. After hearing the submissions made by learned counsel for the parties and on going through the provisions of amended provisions of Rule 143, it is clear that the core controversy in this case is between the widow and the unmarried daughter of late Ujjal Deori as regards the share in the family pension. The rights of the petitioner and the respondent number 8 to receive share in the family pension is unquestionably governed under the amended provisions of Rule 143 of the pension rules, which makes it clear that both of them would be entitled to a share in the family pension in equal proportion. Full stop. Such claim would, however, be subject to furnishing the requisite documents stroke certificates as may be necessary under the rules. Full stop. As such, this writ petition is being disposed of by providing that the respondent numbers 2 and 3 shall process the claim of the writ petitioner and the respondent number 8 in the light of the provisions of in the light of the amended provision of Rule 143 of the Assam Pension Rules, as expeditiously as possible, and forward the pension papers to the office of the AG ANE Assam as expeditiously as possible, but not later than 60 days from the date of receipt of a certified copy of this order. First of such proposal shall also include the proposal for proportionate disbursement of arrear family pension, if any, accruing in the meantime. Full stop. It is made clear that the compliance of the above direction would be subject to the petitioner and the respondent number 8 submitting the requisite documents in a time-bound manner. The petition stands disposed of.
For respondent number 4, my senior Sri Kiran Chaudhary is appearing. Now, see, he is on legs. Now, see, may I appear to take up this matter?
Mr. Mahanta,
My lord.
have you seen there is some development?
I've seen.
You have to challenge this now. That
Lord,
chapter is gone.
May I pray, let it come up on 12th, next Wednesday, this matter. We'll see meanwhile.
On the request of Mr. In view of the office order dated 5/11/2024 issued by the officiating director of LGBRIMH Tezpur, whereby the writ petitioner has been retired from service at the age of 55 years by maintaining the earlier position. Mr. K.K. Mohanto, learned Senior Counsel 6, posting of this matter again on 12/11/2024 so as to enable him to obtain updated instruction. Who is appearing for the respondent? Mr. K. Gogoi.
For 1 and 2.
Learned CGC is present on behalf of respondent numbers 1 and 2. Mr. A.K. Datta, learned CGC for respondent number 3, and Miss
R. Kakoti.
R. Kakoti, learned counsel for the respondent number 4.
Obliged.
Item 12.
My lord, I have prepared a list of three, my lord, for easy reference.
Yes. So what is the matter about Mr. Chauhan?
My lord, I was suspended, my lord, speculating.
I am not asking, what is the relief you want? You
My
want
lord,
to be
I have
suspended?
national promotion, my
Huh?
lord. Benefit of
You
promotion.
have already retired.
Long back, my lord, 2010.
Then today how it can be given?
My lord, because my lord, I could not prefer my lord appeal petition, my lord, because my acquittal was 2015 by my lord special court. And thereafter, my lord, I prefer my lord two consecutive my lord representation. Thereafter, after 3 months gap, my lord, because my lord, I observed my lord appellate period. Then in my
You should have come there to keep it in seal cover. How now? How can a DPC be held today? Show me a judgment which permits. How it can be done? You are unnecessarily flogging a dead. 14 years back, your client is retired. Now you want promotion. Not possible.
My lord,
No. You should have come then. That if I am acquitted from the criminal case, then I should be given all. That time the consideration should have been kept in seal cover. Otherwise, not possible, Mr.
My
Chauhan.
lord,
You get 5 minutes, finish your arguments, I'll pass the order. These are wastage of court's time. There is no such legal principles don't permit. You should have then come to the court saying that I am eligible for promotion or I may be acquitted tomorrow, so consider my case and keep it in seal cover. Then the seal cover could have been opened and given effect to. Today, after 14 years of your retirement, what will the FCI do? They will consider your case against whom? Which vacancy?
my lord, that is why, my lord, I am only for benefit of promotion.
No, it cannot be given. Benefit cannot be given.
And my lord, I could not, my lord, prefer because of my lord, my CBI case hanging on me, my lord, and it was disposed on 2015.
It's not explanation. It's not permissible under the. Show me a ruling which says it is permissible, I will consider your case. You are asking for something which is not permissible. Because benefit cannot be given like this. It has to be against a particular post, particular pay scale, particular budgetary sanction. Where from suddenly money will come to you? You have to say against which post you are seeking consideration, why you did not ask for it earlier. All these things you have to say.
On Tuesday, my lord, next. Tuesday next.
We'll dismiss it in the next round. Huh? He might not be aware. So just one chance. After arguing this matter for some time, Mr. R. Chauhan and a counsel for the petitioner seeks posting of this matter again for hearing after 2 weeks so as to enable him to examine some of the legal issues arising in this case and address this court. Mr. P.K. Roy, Learned Senior Counsel, assisted by Mr. A. Chakravarti. S.K. Chakravarti is present on behalf of the respondents. List accordingly.
Item 30.
On last occasion, the record was called for, record has come.
What is this matter?
2008, my lord, he retired from service on the basis of the PF document. And thereafter, in the year 2011, he filed a complaint before the labor officer. And accordingly, my lord, the Labor Industrial Tribunal started the proceedings. And by judgment dated 2016, my lord, it has been held that the driver has produced a copy of the LIC documents and the school certificate, which is class 6. My lord, on the basis of that, they said, my lord, that PF document, which is there in the record of the management, my lord, they said that it is not correct. And so can it be done, my lord? After his retirement? Question is that, my lord, 3 judgments are there. He has taken his provident fund, he has taken his gratuity. Then thereafter, in the year 2011, he files a complaint. But here one. Seven. Where is the order of the labor court? Labor court is at page 38, relevant is 49, 50, 60, 61.
There's something wrong in the first paragraph of the award. He was initially appointed in 1991 and then while working as such, he was
I'm for the
appointed.
management, Malla. I'm for the management.
I'm not asking.
Yes,
that. There's something wrong in the first 3-4 sentences of the award. He was appointed in 93 and while working as such, again he was appointed in 83. What is the
No,
meaning
no.
of this? You must not have read it.
Appointed in the year 81.
What 81? It says 91.
No, no. That is some mistaken. With effect from 91, 3891, 3881.
He retired or he was terminated?
No, he was retired. He retired.
But here it is written is terminated.
No, no, that is wrong. PF কাগজটো ক'ত আছে? PF কাগজটো? Nomination form. That is. Notice no it. Termination also termination. Yes. Therefore, my lord, he having been superintendent on 36/2008, my lord, then he cannot claim his, my lord, that his date of birth is wrong after taking his provident fund and also the gratuity in the year 2011. He has made a claim on 15/12/2011, and senior manager, on the basis of the letter from the labor officer, my lord, senior manager has addressed a letter on 26/6/2012 at page 35. So law is very clear, my lord. After having retired, my lord, he cannot correct your date of birth. And that also on a document, my lord.
Where is the decision?
Decision. Three decisions are there, my lord. And that also on a decision, documents which is not before the management. My lord, in annexure E, your lordship will get paragraph 7 to 14. Annexure B, paragraph 8, 12, and 14. Yes. Yes, you are appearing?
Yes, ma'am. My lord, in this case, what happened? In fact, in the master roll and all the records of the management, my date of birth appears as 1956, 31/10/1956. And I have annexed the master roll also at page number 93 and 94 of my affidavit in opposition.
So, Mr. They forget everything else.
Ma'am.
Only thing is, this order of the tribunal cannot be implemented. He cannot be given benefit unless he works. In these matters, assuming that there is a mistake, the date of birth is corrected, the relief can be allowing him to continue in service till the age of superannuation.
Yes, my lord.
It can't be that. So forget it. Even if he has not worked, give him the salary. That order cannot be passed.
No, my lord, I was supposed to work till the year 2014. Then
But you have not worked.
No, but because I was terminated, I went to them that my age of superannuation should be the year 2014. But they did not accept it, and they were unhappy with me. That is why post-datedly they issued a letter of termination citing the PF nomination form, ignoring their own master rolls and other documents.
They were very wrong. Show me a judgment where you can get the benefit of pay, etc. without working. Show me a judgment.
My lord, there is one judgment of another high court, if I may mention.
And you worked somewhere for 3 years. After 2008, you worked for 3 years and in 2011 only you raised the dispute.
No, my lord, I approached them only. I said that please allow me to work because you have suddenly terminated me. Where do I go now? They said we will extend you, give you a fixed pay of and work as a driver for us. Then there again they terminated me, my lord, because I was very poor. And so it took me some time to approach the labor officer, my lord. That is all. Otherwise, I have passed away now in 2020. This person passed away. Thereafter, he has been substituted by the legal representatives, my lord. So I have not worked. That is, in fact, it is admitted in the award, it is recorded that I have not accepted the PF also, my lord.
What will be the benefit now? What benefit?
The
you will get?
only thing is
Mr. Das, what will be the benefit? Finish it off. Give it a little bit, give them the legal aid, something.
I'll have to
obtain
rely on your
instruction.
lordship.
Sometimes you have to be human also. We'll mold our order in such a manner that.
I leave it to your lordship.
What would be the benefit even if he gets it?
Not difficult because 2014 his date of retirement is otherwise.
No,
as per this thing.
let's not get into the legalities.
No,
I'm saying.
lump sum amount your lordship will grant.
Yes, some lump sum amount, give it. These are poor
Lordship
people.
will grant it, my lord, under taking into consideration the plight that they are divers and his wife is there. You know.
So can you indicate a figure? Not, it will not go on record, live stream. An attempt should be made even at this stage to reach an amicable settlement in the matter which is acceptable to both the sides. Full stop. In the light of the above observation, learned counsel for both the sides have prayed for a week's time to seek instruction from their respective clients. Full stop. In view of the above, let this writ petition be listed again on 12/11/2024 as a fixed parted matter.
There is only the wife is there with the other two children, they are adult. So we'll have to consider.
So you said 2.5, see if there can be little plus minus.
I leave it to your lordship. This kind of situation, my heart goes, my lord.
You also have to be reasonable, huh? Because. All right,
I'll leave it to you.
Much obliged.
May I please your lordship? There are two similar cases has been disposed of.
Dismissed.
Disposed of.
You are for the petitioner.
Yes, sir.
The writ petitions have been allowed.
Yes.
Why are you saying dismissed?
Dispose of your lord.
Dismissed of, you said. Yes, what do you say?
Well, I have to go through it, but I have not received the. I have examined it, madam.
All right, Miss, your name please?
M. Bhattacharjee.
M. Bhattacharjee, learned counsel appearing for the writ petitioner submits that the petitioner's case is covered by the judgment dated 1/5/2024 passed in WPC number 7201 of 2018 and 8803 of 2018, whereby the prayer made by similarly situated writ petitioners have been allowed by this court. First up, as such, this writ petition we also disposed of accordingly. Mr. H. Gupta, learned CGC, prays for 1 week's time to examine the aforesaid judgment and order dated 1/5/2024 and make his submission. In view of the above, let this matter be listed after 10 days. Now.
Lordship, this, UK Goswami is there in this case for the other side. He has informed me he is on legs in some other court, lordship. Can it be taken after some time, lordship?
F2? That I can't say. There is only one more matter or two more matter. Let us see. Otherwise, it will go to some other day.
May I please, your lordship? This is an unfortunate government employee, lordship. His regular pension was held up, lordship, saying departmental proceeding and judicial proceeding was there. In the meantime, they, on last occasion, they submitted that departmental proceeding they have dropped, lordship. So since he is not guilty, the prayer is for pension.
My lord will peruse the order dated 19/9/24, my lord. The last order.
Proceeding to what like this?
So departmental proceeding has been dropped.
Departmental proceeding has been dropped, but that, my lord, criminal proceeding is still on, my lord. That is not closed.
So,
my lord, my lord, she, as of now, my lord, she will get provisional pension, but final pension, my lord, she will not get this moment, my lord. That is the thing, my lord, that there is an OM to that effect. So we have placed that OM, my lord, on the last occasion, my lord. And thereafter this order was passed, and my lord, my friend was supposed to reply on that.
Lordship, there is an order of this honorable court, lordship, on that point. Judicial proceeding, lordship, till date, no charge sheet has been filed. And
where is the OM? Which OM is there? Let us see. The copy is there on record.
My lord,
charge sheet with the final notice. They can held up if I find guilty, lordship. Till date, no charge sheet.
Where is the OM?
OM, he has.
my lord, we place it, my lord, again.
Of 2012, lordship. Thereafter, this honorable court passed another order, lordship.
So then why haven't you released this provisional pension since August, September, October, we're in November?
We can release, my lord. Provisional.
It means you will have to.
No,
Yes, my lord.
provisional pension, he is getting.
Oh, he is getting. We release, my lord.
Provisional pension, he is getting, lordship.
I say. One and June.
So there is something which says no decision.
Lordship, in 2021, Lordship, this honorable court passed an order regarding same matter, Lordship.
Setting aside this notification.
No, not setting aside, but saying that Lordship may kindly peruse this order. Para 20 and 21 is relevant, Lordship. Judicial proceeding শেষই হবে না, লোকটা মরেই যাবে। He is bedridden, that is why we are. বেমারি হয়ে বিছানাত পড়ে মরে যাওয়া একজন। এবার কি করে হেরে পড়ে? In this case also judicial proceeding was pending, Lordship. He is not guilty till date. He is bedridden, Lordship, 60, 66, 67 years old. For his own ailments, he required some financial assistance, Lordship. দেখেছেন? And in pension rules also says, Lordship, if he finds guilty, till date no charge sheet has been filed, Lordship.
But should you not have filed an affidavit at least assailing this notification?
They have not filed anything. They just submitted on last occasion.
Then nothing can be done. We will have to follow the requirement of legal procedure. No? There is a notification which they are relying upon, according to which it cannot be finalized. If you
Lordship.
don't challenge it, then what can be done? These are all
But
arrogant
after
stand.
this, Lordship,
These are all arrogant stand of counsel. You should
Lordship.
understand how the law. On the prayer of Miss S. Kanungal and counsel for the petitioner, this matter stands adjourned for 2 weeks so as to enable her to obtain updated instruction. Mr. Ardhar, learned additional government advocate Assam for the state as well as Miss. So for the respond number, 4 are present. You have to do it, otherwise it can't be helped. I can distinguish the judgment and dismiss the writ petition today itself if you want.
Lordship,
You have to follow the requirement.
Lordship.
There is a governor's notification, you have to challenge it. We can either read it down, set it aside or overcome it. But once he has pointed it out, we cannot ignore it. You
Same.
can do it. We can't.
No, Lordship, I can.
We can do it. You have to do it.
Challenge for deeply obliged. Notification.
Thank you, sir. My lord, in this writ petition, my lord, the board has taken a decision to give the pay scale to the junior engineer who is working at page 41. Your lordship will see the party board resolution taken in the meeting of Badarpur Town Committee, my lord. Page 41, the scale of pay is allowed to Sanjeev Majumdar, junior engineer of this office with effect from 1/7/2014 in the pay band of 5,200 so and so with grade pay so and so, plus other allowances as admissible to the employee of this office. It may be mentioned that Sanjeev Majumdar was appointed as junior engineer at this office on 31/3/2010 with a fixed pay of rupees 4,500. The details of the Sanjeev Majumdar is enclosed here for your ready reference. After threadbare discussion, board has taken a resolution, board, my lord, to pay salary as per scale in the following ways.
You are reading from which page?
Page 41, my lord. That is the resolution of the board. Page 41 and 42 is the next one. So here, my lord, in pursuance to a resolution and decision taken by municipal board of Badarpur, my lord, town committee, now board, Badarpur town board, my lord, they have taken a resolution on 1/7/2014, my lord, as per resolution number 5, to extend the pay scale to the junior engineer And petitioner is the only junior engineer working in the post since 31/3/2010, my lord. And who has been entrusted with all the duties, my lord.
So now what has happened? What action has been taken on this?
Now, next page is page 42. That is by the post serial number 5, my lord, page 42. Post against which he was appointed is the junior engineer. So now it is a self-institution, my lord. Municipal board being a self-institution, the Assam Municipal Act says, my lord, the board has the power to appoint and extend this scale of pay under section 46. Now, till now, my lord, in coming to the to the point, my lord, till now, my lord, that resolution adopted has not been.
This resolution of 2014.
14, my lord.
Then you have come to court in 2022.
22, my lord, since, my lord, it's a continuing cost, my lord, that every time when they pay the salary to me, my lord, I get the less salary than what should be given to me, my lord. That is.
So let it continue for another 10 years.
I have, my lord. Thing is, my lord, this. The junior engineer is a responsible post and only junior engineer, my lord, I have shown. When you differentiate with other, my lord.
Close the door.
Petitioner is the only junior engineer, my lord. And if they make a classification
So what has happened? The director has not approved this.
my lord, possibly, my lord, on last occasion also, my lord, director approval is not required. Because it's a
The
self-institution.
instruction received, lordship, director approval is not required.
Not required, my lord.
So then who is appearing for the Badapur Minta?
My friends.
So you have sanctioned it, give it to him.
Difficulty is that lordship, we don't have any independent fund, and more to that, whatever instruction that has been received and based on which the affidavit has been filed. This is not complete lordship because I have been recently engaged in this case and I have gone through the affidavit. In the affidavit, all the facts and figures are not properly mentioned. So at least some time, 1 week time or 2 weeks time may be given so that I can incorporate all the relevant facts. Because the relevant facts, because in the one hand, we have not mentioned anything with regard to this particular annexure. At the same time, if your lordship kindly see the affidavit that has been filed by the municipal
board is filed.
Yes, municipal board. In that particular municipal board, the annexure B,
Municipal board is response number?
municipal board is lordship, the response number 5.
Executive officer.
At that
Which
point of
paragraph?
time, the executive officer.
Which paragraph?
Yes, lordship, this paragraph number, 14. Paragraph number 14. That with regard to the statement made in paragraph 15 of the writ petition, the deponent begs to state that the Badalpur Municipal Board authority is presently not in a position to grant scale of pay to any of the employee as instructed by letter number such and such. There is a communication of 2020. In view of that, it has been
It's not a
annexed.
question of granting. Grant has already been made.
Yes.
It's a question of releasing the
Yes,
arrear pay.
lordship, kindly see the particular communication, the annexure C, lordship. Annexure C is the page number 62.
Then we'll suspend the salary of other members. That is the only way out.
That is the difficulty, lordship. That's why I'm just praying for some more time so that I can get the details instruction with regard to that, because this affidavit is very cryptic. It has not dealt with all the
That's
relevant
right,
aspects of the
but see,
matter.
the point is,
Yes.
the board.
Yes, Lord, the resolution is there, lordship. That I have seen, lordship. With regard to that, there is.
resolution is
Yes.
still there.
Yes, lordship.
So with effect from the date of resolution.
Yes.
He will be entitled to that.
Exactly, lordship. The difficulty is there.
Whatever
Yes.
arrear, that has to be paid. And current salary has to be in that scale. If you say that there is no money, then we'll recover it, we'll suspend the salary, etc. of the other members, chairperson and all.
Let me get the instruction,
My
lordship.
lord, the board itself
Well,
has.
the judge is conversing with the lawyer in your favor.
My lord,
It is a very bad behavior to intervene.
I'm sorry, my lord.
Don't do it ever.
Lordship, I'm just praying for some more time, at least 1 week time, because I've been recently engaged in this case. All the details, facts are not there in the affidavit itself. Can it be taken up any day in the?
All right, but what fact you want to, what? fact
Lordship,
you-
with regard to the resolution and what has happened after that, why it has not been released, all these relevant aspect of the matter should be there. Because in one hand, in the paragraph number 15, they are saying about this some sort of restriction. On the other hand, in paragraph number with regard to this particular annexure.
Restriction, fund is not there.
Exactly, lordship.
Fund will take out.
So
That is not a problem.
let me get the instruction, Lordship. Can it be
Fund
taken
will
up?
take- Whatever the fund will take out the money from there.
I can understand,
Where
Lordship.
do you get the
Yes.
fund? Bodapur Town Committee gets its money from where?
From this respond number, this. Be getting the funds.
Hmm.
Probably from this response number 3, Lordship, the Director Municipal Administration.
I will
Yes.
ask I will ask the director to delete that, withhold that amount and give it to the petitioner directly.
For that reason, Lordship, let me get the instruction. Can it be taken any day in the next week, Lordship? I will obtain the necessary instruction with regard to this relevant aspect of
Heard
the
Mr. B. Barua, learned counsel appearing for the lead petitioner. Also heard Mr. H. Chakraborty, learned Bombay Republican Assam appearing for the respond numbers
1, 3, 6,
1, 3,
and 6.
and 6. And Mr. P. Nayak, learned Standing Counsel Finance Department for respond number 2. Mr. S. P. Chaudhary, learned counsel has appeared on
4 and
board
7,
respond
Lordship.
numbers 4 and 7. First up, the primary grievance of the petitioner is that notwithstanding the resolution dated 6/9/2014 of the board of the Badarpur Town Committee granting the benefit of pay scale to the petitioner who was appointed as a junior engineer, no pecuniary benefit has been given to him till today on one pretext or the other. Full stop. After going through the materials on record, it appears that the only ground on which the petitioner has been denied the benefit of the pay scale is on account of paucity of fund. First up, once the competent authority under the law has taken a decision to extend the benefit of pay scale to the petitioner, and such decision has been circulated by the concerned authority, a right would have been deemed to have been accrued upon the employee. First up, therefore, such right can neither be taken away nor be denied to the employee merely on the ground of paucity of fund. Full stop. This court had therefore posed a pointed query to Mr. Chaudhary as to why a direction should not be issued to the respond number 3 to set aside the fund for release of arrear pay of the petitioner directly by deducting the amount from the allocation to be made to the Badarpur Town Committee.
Lordship, this is otherwise not required. I will obtain the instruction, Lordship.
No, this is what is happening.
No,
We-
I will
we
obtain
have
the instruction.
seen it.
Before next date, I will obtain the instruction, Lordship.
No, then you delete this part. Mr. S.P. Chaudhary, learned counsel, submits that he has been recently engaged in this case and therefore be given 2 weeks' time to obtain specific instructions so as to address the issues raised in this case. On the request of Mr. Chaudhary, this writ petition is
First week of December, Lordship.
listed again on 25th of November
Right.
2024 as a
Right,
next item.
Obviously.
No, but
Yes,
then we'll pass that order.
Definitely, Lordship. I
We'll
will
pass
obtain the
that order.
instruction. Time being better, I can.
This is the last matter, Mr. Chetri.
Yes.
So we'll have it on 19th of November, 19th. Mr. B. Chetri, learned counsel is present for the petitioner. This matter was called up twice during the course of the day for hearing, but on each occasion, the learned CGC representing the respondents was unavailable for conducting the hearing of this case. First up, since it is a matter of dismissal from service, hence undoubtedly there is some urgency in this case. First up, however, in order to avoid any prejudice being caused to the respondents and so as to afford one more opportunity to the learned CGC to appear and argue the case, this writ petition is directed to be listed again on 21st of November as a fixed. 21st, you are not available? 21st of November as a fixed item for hearing. It is made clear that no adjournment will be granted on the next date fixed.
My apologies, Lordship, I was not here at item number 7 and 8, my lord. Caught up in court number 1.
Bless you.